Okay, so there have been some questions, and they're fair questions. I didn't bring them up in my original video because I didn't think they were relevant, right? So I didn't think it was relevant what the specifics of my relationship to my ex-wife was, or the elements of the child support. I thought the real salient point is that this case would establish that a private individual could prosecute another private individual for the sole purpose of gaining a criminal result, getting someone put in jail or fined, and that is a huge deviation from the American jurisprudence system. American jurisprudence system is founded on the idea that you can't get someone locked up for things like failure to pay a debt or damage in your car. That only the state can come in and launch a criminal prosecution against someone. And I think that is the real matter of outrage that should inspire anyone who is watching this to say, oh yeah, I need to back this guy. I do not want my neighbor dragging me into jail because I failed to comply with the city's ordinance on cutting my lawn properly, or because my kids are trespassing on his lawn. That to me is the real danger to the wider community, and the reason that people should look at me and say, oh yeah, I need to help this guy to make sure that that doesn't happen, and that they should have the opportunity to correct this and be eager to join in that. It's the reason that I've kept going. It is a sense of obligation to me at this point. To be completely frank, it would have been much, much cheaper, on the order of tens, now approaching hundreds of thousands of dollars, to have just made arrangements to go in and serve 38 days in jail, arriving on Friday, leaving on Sunday, over the course of 6 months, and just feel that obligation and moved on with my life. But my lawyers have pointed out to me, and I have to concede that I have a civil obligation, like a responsibility to the American society to fight this. That if this were allowed to stand and be a part of established law, it would be a dramatic change, and it would be on par to what's happening in Texas, where Texas is allowing private individuals to drag other private individuals into court for violating their ordinances on abortion bans, and this would be that same sort of thing. So, however, given that that preface, I do understand that people want to know the details of what happened there, and so I am going to deviate into some areas that are in dispute, right? So these are not, like everything I put forth initially, there's no one disputing it. Right? Everyone agrees on the elements of that. Right? There's no one who's saying, oh, I disagree that this is what happened. Right? Like that is all just matter of observation and mutually agreed upon facts. There's no one presenting a different slate of facts on the original thing. But here we are going to get into stray into some areas of dispute. So prior to September of 2016, I was making my child support payments directly to Marisol, right? I would make deposits directly into her bank account. And like I said, in February of 2016, I was facing a period of unemployment. Wanted to make sure that I was covered as far as child support goes, and so I made arrangements to cover that child support for up to 3 months of child support. And then resumed child support payments in July of 2016. Then in October of 2016, well, so in September of 2016, things had gotten so bad between Marisol and me that I didn't want to have anything to do with her, and she turned over the handling of the child support to DHS. So beginning in September, it was DHS who was processing the payments, and I think as part of that, she had to swear an affidavit of the payment history, and maybe even had to submit verification in some form. So then in October of 2016, Marisol refused to let me see my daughter. And so I had to take her to court to resolve issues regarding visitation. So as part of that too, we wanted to clear up things about the child support history. Because like I said previously, Marisol and I had filed the divorce decree ourselves and only used a lawyer to actually do the filing. And there was a lot of language in there that was really badly done. We had formed our divorce under the presupposition that Marisol would be returning to Mexico City, although whenever she decided to make that move in February of 2016, she gets to Mexico. Her family's like, "No, it's crazy for you to move back here. We don't have a job for you, and you're much better off raising your daughter in Tulsa." And so she returned and so she wasn't living. So there were just many things in the original divorce decree that didn't make sense because of that. So like in the original divorce decree, the visitation had me taking Daniela continuously from May until September, which would have been when she was out of school in Mexico City, and then could have come back to Oklahoma to stay with me through the summer and then gone back there to go to school in the fall. And that makes sense in that situation, but it doesn't make any sense when we're living less than an hour away from each other. And so, Marisol's not letting me see Daniela, and we're going to court, and my lawyer's like, okay, and we need to get this all amended and have it in a sensible way for the current situation. So there was going to be a lot of revisions and a lot of negotiations, and Marisol had retained a very aggressive lawyer, Mark Lyons, at that point. His aggression is to the point that it's unethical, just to be honest with you. He has no qualms standing up and saying things that he knows are false in court. And he's on the record of making statements that are just categorically false. He had to know that they were false when he made them, and he has no problem standing up and lying to the bench. He sees it as just a part of his duty as a very aggressive advocate. But that's a whole other rabbit hole. So we're going to have our whole divorce decree revised under the supervision of the court and with contentious litigators involved. And at that point, my lawyer, who I'd retained, said, "Look," he said, "you understand that this is going to be a very contentious process, and I can tell you, this is just a known fact that in Tulsa County we have this bench called the Rocket Docket. It is specifically designed for fathers who are not paying their child support, to get them in, get relief like in a matter of hours, not days. The judges there, in particular, are extremely hostile to fathers. Like that is by design, right? Like if your ex-wife's lawyer is going to want to get you into that court, like that, and he's going to want to get you there because once he has you in front of that court, he can then say, look, we will negotiate everything together, including that, to get the best concessions he can in the final decree. So my lawyer said, you need to make very sure that you are good on child support, right? So he said, are you good on child support? You're not behind in child support at all. I said, no. I said, no, not only that. And I said, but if you actually go by the DHS formula, I've been overpaying by about 100%. Like I should have been paying $600 a month or so in child support, and I've been paying $1,200 since we divorced because I wanted my daughter in a good preschool. He's like, okay, that's great. So then, in looking over, and that was exactly what happened. So Mark Lyons is looking over the record of payment, and he sees no payment for March, April, or May. Right? It's not until it was actually June whenever I resumed. No, it was July because I paid upfront 4 months, so March, April, May, and June. It was July whenever I resumed justice. And he's like, okay, I got him. He didn't make his child support payments in these 4 months, and so he gets me in front of that bench. In February of 2017, I get a summons. I get delivered a subpoena to appear in front of that, and so I plead not guilty, and the judges asked me, says, okay, says you plead not guilty, we'll have a hearing, and I'm assuming she said you're going to waive your right, you're going to have a bench trial. I said, fuck no, I'm not going to have a bench trial. I'm not going to leave this up to you judges. I want a jury. And she's like, okay, you clearly mad, like that. Completely short circuits the entire premise of that court. That court is meant to have fathers in there in a matter of hours, and here was a father who was exercising his right, who he knew he was guilty, he knew he was innocent, and was exercising his right to have a jury decide it, which was, instead of that case taking, I don't know, 2 hours at most of the court time, including testimony, now we were going to have to commit several days to an actual trial. Very mad. The judge was obviously extremely mad at that point. And it was also shocking to the other people, like the other litigators who had fathers in similar situations, that anyone would take a course of action that was clearly so provocative to the judges. And in retrospect, I understand that I antagonized the system there, right? Like that system was designed for a very efficient hostile rendering towards fathers, and I was resisting that. And so you could say that I asked for it, right? And the judge was just overtly biased against me. They were like, there's no denying that at trial, right? So anyway, between that point and trial, because DHS showed up with Marisol, like as a and filed a co-complaint, which confused me, right? Like I said, DHS has taken over payment processing in September of 2016. And so it confused me that DHS was there saying, yes, we agree that this father is behind on child support. So I contacted DHS and asked what the deal was. And they said, well, we're not showing a record of payment for these 3 months. And I explained, I said, yeah, I prepaid all of that. Are they denying that? So they said, well, really, we don't care what Marisol says, right? So just as we have to show a monthly record of payment. Like that's just, and we are not designed, and we are not going to alter our processing to accommodate lump sum prepayments, right? Like you could decide to say, well, I'm going to pay the entire child support until she's 18. And we would say, no, you can't do that. But we are not designed for that. We keep a zero balance each month, and we are not going to carry a positive balance and draw it down for you. You need to make monthly payments of the amount owed. And I said, well, what about that lump sum? They said, that's between you and Marisol. Said, we're going to show you as being behind in child support until you provide us with 3 discrete payments for those months that you have missed. So I was like, okay, that's fine. I'll go ahead and put that money up front under the expectation that I'll get it returned to me from Marisol. And then at that point, so I did that. I got, so that the HS's records showed that I was 100% in compliant. That was in August of 2017. And at that point, DHS withdraws from the case and informs Judge Doss that I was current in child support, that there was no remediation option, that it was purely a matter of it would be purely a matter of deciding guilt and issuing a punishment, rendering a punitive and that's not the purview of DHS. That would be a criminal prosecution, not something that the Department of Human Services does in child support cases. And so my lawyer files a motion to dismiss at that point, saying, since he's current in child support, there's not. Marisol's lawyer says, no, we should still go to court and decide issues of guilt in front of a jury. He's asked for a jury. We should. And then if he's found guilty, then he has the punishment options. And so my lawyer's like, you can't do that. And Judge Doss says, well, I'm going to let him. I'm going to let him do that. Yeah, I'm going to let him. I'm going to let this one private citizen take this other private citizen to court purely to determine guilt and issue punishment. No possible remediation involved. Now, what I should have done, right, was change lawyers right then, because what Gil Pilkington should have done was immediately filed an appeal. Right, it's called an issue of standing. I've come to learn, because Marisol doesn't have standing to bring a criminal case against me. But Gil Pilkington is not a litigator. He's used to dealing with couples who are working together to try and find a reasonable solution. He's not used to someone like Mark Lyons, who's just a vicious litigator, right? He's going to do everything, including lie to the court, to win. So I should have changed lawyers but I didn't realize that. So what happened in the aftermath of that was Gil Pilkington says, well, I think it's reversible error on Judge Doss's part. Said, once the trial is complete, we can file an appeal. So anyway, the details at the trial, there are several things that went wrong. The first one is that Gil Pilkington's strategy was to show the jury that I was actually ahead in child support, that I was way ahead in child support, and then show them the legal fact that if you are ahead in child support under Oklahoma Constitution, you are not guilty of failure to pay child support, which I know sounds oxymoronic. It's like my but that was his strategy. And then, so the trial began on Tuesday. On Monday morning, Judge Doss calls both lawyers into her office and informs Gil Pilkington that my current status regarding child support is not relevant, that she will not allow the full history of it in, that if he wants to show the history of that either party could introduce the window of dispute, right? So the window showing where I did not make 3 months of payments, right? But that she would not, but that whether or not I was current in child support was not an issue. The only issue was whether skipping those 3 months of payment constituted a violation of the court order. So then the other element that comes into play in indirect contempt of court is whether the violation was willful, right? And so that was kind of what we hung our case on, right? So our point being is, look, he thought he had satisfied the divorce decree. Like he thought he was in compliance. And the fact that he thought he was in compliance was not a willful violation of the divorce decree. And then Lyons' counter to that was, well, look, he willfully violated the divorce decree when he prepaid, right? Like that's not what's in the divorce decree. The divorce decree, and as enforced by DHS as part of their policy, is a monthly payment, not a lump sum prepayment. And so even if you believe, because at trial, Marisol claimed that the March payment was just for March, and that I had included the extra purely as a gift. That the amount that I had stated was intended to cover the next 3 months of child support, that had just been a pure matter of I don't know what you'd call it, beneficence on my part. There was I had not conveyed to her and in any way that was intended to offset child support. And then so Lyons says whether or not that was the case, whether or not you believe Marisol or not, or you believe me, was not relevant. That the only relevant issue is that I willfully violated that divorce decree whenever I chose not to make monthly payments. And then so jury goes out to deliberate. The jury sends out and then Judge Doss's jury instructions confirmed Mark Lyons' line of reasoning that really the only thing was relevant was whether I violated the divorce decree's order to make monthly payments, that my current status or any prepayments or anything was not relevant. That the only issue in to be decided as a matter of fact was whether or not I had violated the court order, the divorce decree, whether I had done it willfully, and then the level of confidence they had, whether they believed that by a convincing evidence or beyond a reasonable doubt. So jury comes back, issues a guilty verdict. And then at sentencing, Judge Doss sentences me to a fine. I think it was $1,000. I forget what the fine was. And 45 days in jail. My lawyer says you can't do that. That's purely punitive. Violates HIBIT, which is so in Oklahoma case law, there was a case where a wife tried to have her husband sentenced to jail because he had violated their divorce decree. He had been coming onto her property she had taken control of in the divorce, I think was the story. It's called Hibbert. You can look up the details of it. And she wasn't claiming any damages or anything, but their divorce decree said that he had to stay off the property. He was violating that, and she just wanted him put in jail. And then in Hibbert, the ruling was no, you can't do that. Like if you're bringing your ex into court, there has to be a matter of remediation involved. It's called coercion, and you can put someone in jail until they satisfy the coercive element. So if someone is behind in child support, you can put them in jail until they get caught up in child support. But you can't just say, well, you at some point violated your divorce decree. That's contempt, and we're going to put you in jail for that. Only the state has the right to do that. That's a criminal prosecution. Only the state has the right to do that. So, my lawyer, Gil Pilkington, he does point that out to Judge Doss. Judge Doss says, yeah, I've looked at Hibbert. I disagree with it. I'm sentencing him in jail, and he's going to jail right now. It wouldn't even stay the sentence pending an appeal. So then the Oklahoma State Supreme Court, Gil Pilkington does get it to the Oklahoma State Supreme Court in less than 2 days, less than 48 hours. They issue, this is, so she sentences me on a Tuesday afternoon. And by the time I was sentenced, the courts were closed. Like that was the last action of it. It was after 4. And so it wasn't until Wednesday that Gil Pilkington was able to file the brief with the Oklahoma State Supreme Court saying, look, here's what's going on. This can't be right. Oklahoma State Supreme Court looks at that on Thursday, and then on Friday they issue a writ of habeas corpus instructing the Oklahoma County the Oklahoma County Jail to release me, and instructing and to release me immediately, and that if Judge Doss wants to set wants to then bring me back into court and set a appeal bond, that she can do that. But in the interim, they were issuing an appeal bond amount of $1,500. So that is, the instruction was writ of habeas corpus saying release him on $1,500 as soon as he posts $1,500 for an appeal bond. Gil gets that at 4 Friday afternoon. He gets it to the Tulsa County Jail at like 4:55. Tulsa County Jail says, well, it's too late today to do anything about it. They have a weekend court session to handle bonds and stuff, and that they will address it Saturday morning. Saturday morning, I go into that expecting to be released on $1,500 bond, which had already been posted, like it was already. The judge at that says, well, before I release this guy, I'm going to contact Judge Doss. So they contact Judge Doss. Judge Doss says, no, don't release him. I don't want him. I want him held as long as we can. So don't release him. And so, so it's actually Monday afternoon before Gil Pilkington threatens the Tulsa County Sheriff with contempt of court if he doesn't release me on the writ of habeas corpus, that I'm released from jail. So I served 7 days. So there's 38 days pending. So that's where we are now. I've been appealing it. Gil Pilkington wrote the initial appeal. It was badly written. His appeal, rather than going in, which he should have done, and focus exclusively on the fact that this trial should have never taken place, that Marisol lacked standing to bring the case, he convoluted the matter, didn't even include that really. He in his appeal, he argues points of evidence that, like, they had failed to demonstrate that I had knowledge that I was violating the court decree, and that you can't be willful if you don't have knowledge that you're violating the divorce decree. Anyway, and he had a very convoluted, and his appeal was all focused on things that happened at trial, and at the time he was filing it, I'm like, why are we doing that? Why aren't we just saying, hey, look, she's a private citizen, she can't bring another private citizen in for criminal? And he said, well, that would then cause that would put the appeal in the situation of the Court of Appeals saying that, like, Judge Doss unequivocally did something that was very wrong, that she was just a bad judge, that in choosing to ignore this matter of jurisprudence. And he said, the Court of Appeals, they're all judges, and they just like it. This is a matter of policy. The very last thing they do, only if they have no other choice, will they say, this judge is a bad judge, right? They just won't do it. It's like asking a doctor to come in a court case and say, this doctor is a bad doctor, right? They just don't like to do that, right? They're judges themselves, and they don't want that out there as a matter of public information, right? So he refused to do that. So he goes ahead and files that appeal. And I'm like, okay, that's it. I'm getting a different lawyer. Like, this is just too much. Like, you're just clearly not suited for this. And then my new lawyer is like, yes, you're right. Like, he should have. This is one of those cases. This is one of those situations where absolutely he should have gone to the Court of Appeals, say, look what this judge is wrong. Judge, you just cannot let a private citizen bring another private citizen into court for the sole purpose of criminal punishment. That's just so wrong. Like, if you allow that, then like you just, within a matter of, as soon as it became known that, yes, in Oklahoma, you can just bring another person into court just to have them punished, that you're going to open up the door. I mean, you're mad at your ex-boyfriend or your ex-girlfriend because she did something wrong to you. Bring her to court. Have her sued for criminal fraud, right? Or your business partner you think has done some things that are unethical. Bring them to court, and if you can convince a jury, you can have them sentenced to jail, right? That structure is just untenable. It's just the ramifications would be horrendous. And so my new lawyer, Christian, he's like, yeah, this is one of those cases, but he said, my hands are tied. It's like, until the Court of Appeals rules on what Pilkington filed, I can't file a new like that's something else that, like, procedurally can't do. And that's to keep you from just like slamming the Court of Appeals with appeal after appeal for the same case, right? Like, so once you file an appeal, you got to wait for that to be resolved before you can take further action. And so in the end, the Court of Appeals, they rejected Gil Pilkington's appeals based upon evidentiary issues, like allowing Marisol, because Marisol had previously testified that, yeah, that was a matter of agreement in some of our other, and so she reversed that at this trial. And so one of the elements that Pilkington included was that the judge was wrong, and that should not be allowed. That allowing a sworn testimony to be completely reversed is a violation of evidentiary. It's called collateral estoppel. Anyway, other things. But in the end, the the Court of Appeals rejected Pilkington's appeal and upheld the trial and the verdict. And at that point, Christian is like, okay, now I can file the correct appeal. And then, so what he initially did was he filed back with the Court of Appeals saying, look, we understand that you rejected that appeal, and we want you to reconsider the appeal under these circumstances, right? And he in particular, he said, I want you to reconsider it under a matter of standing. The fact that Marisol did not have standing to even launch the trial in the first place, and that the trial should have never taken place. So that would void the trial and the verdict. The Court of Appeals just refused to reconsider. But they didn't rule on the merits of the argument. They just said, yeah, we've heard this appeal. We don't want to hear another appeal on this same case. And so then we were like, okay, that's fine. We can take this matter to the Oklahoma State Supreme Court. That's what the Oklahoma State Supreme Court is for. And now we are pending in front of the Oklahoma State Supreme Court. So you can reference the entire history of the litigation between Mike, not just this particular element, but all the other, the emergency motion to modify visitation that I had to file, all the way back. I'm going to put a link there somewhere. I guess you can put it in comments here on GoFundMe. Wow, this is a lot longer than I expected to talk. If you've hung in there to the end, I do appreciate it. I think that I'm giving you the opportunity to participate, not just in correcting an injustice that has been done to me, but but preventing a precedent that would be horrible for our society. That's the reason I've continued, is because if this trial and verdict is allowed to stand, then it would just be a horrible situation in Oklahoma. The idea that any two private citizens could drag each other into court just for the matter of criminal, for a criminal result it violates fundamental principles of American society. Yeah. And American jurisprudence. So thank you for hanging in there till the end. I hope you will join me and in my effort to prevent this horrible thing. Thanks.